There we go. Okay, so this case is, and if you can't see it, I'm going to read it to you. So this is the Commonwealth versus Calvin Carnes Jr. This is the case summary. So page 1. Why this case, or Roman numeral 1, why this case matters. Calvin Carnes Jr. has spent nearly 2 decades in prison, serving 4 consecutive life sentences without the possibility of parole for a crime that the evidence overwhelmingly suggests was committed by his co-defendant, Robert Turner, on January 29th, 2026. Carnes filed his second motion for a new trial in Suffolk County Superior Court, a 112-page filing that presents one of the most compelling cases of wrongful conviction currently pending in the Massachusetts courts. So we're gonna follow that, like, for sure, for sure. I'm not reading you 112 pages, but we'll figure something out. This case is not merely about one innocent man. It is about a window into a systematic failure within the Suffolk County District Attorney's Office, where the prosecutor who tried this case, former ADA Joshua Wall, do you guys know him? I do not. I don't know if he's still around. Also served as first assistant district attorney overseeing all superior court prosecutions. During his tenure, at least 13 men convicted of murder have since been exonerated after the SCDAO withheld evidence and opposed post-conviction discovery. Opposed post-conviction discovery, a track record that stands in devastating contrast to Judge Brady's characterization of Wall's exemplary performance and the office's high degree of professionalism, including reducing Brady violations. The Carnes case involves every hallmark of a wrongful conviction. Multiple confessions by the actual perpetrator that the Commonwealth concealed for years. Massive undisclosed payments for the 2 key witnesses. Who do we remember this? Who does this sound like to you guys in this, Karen Reed, Aiden Carney? So let's pay attention here to, paid witnesses, 2 key witnesses, a forged confession letter designed to frame the defendant. Let's say that again. A forged confession letter designed to frame the defendant. False forensic testimony. Unauthorized juror investigations. I'll tell you, one thing that I saw when I was up in Norfolk County, and I did report this, was there was during jury selection, one of the news organizations had cameras on the ground that was like, it was completely like to get to see who the jurors were. Yeah, you'll hear more about that in this. Interception of privileged attorney-client communications. That is shocking. And a motion judge who wrote a letter of recommendation for the very prosecutor whose misconduct was at issue, citing the Carnes case itself as proof of that prosecutor's fitness for the bench. What do you think so far? Pretty shocking, or this kind of stinks. I have to like go tabs. Okay. Oh, Mary B. Mary B923. Hey, from Rat House Media. How you doing? I wrote you guys a message earlier. You got to hear this one. This is crazy. Oh, I got to stop flipping back and forth because there we go. There we go. Okay. Too many tabs. Like my brain. So, Roman numeral 2, the crime and the prosecution's theory. On December 13th, 2005, 4 young men were shot and killed in the basement of an apartment on Burnside Street in Dorchester, Massachusetts. The victims were Calvin Carnes' friends, aspiring rappers who used firearms as props in their music videos. Visitors to the basement frequently handled and borrowed these weapons. The Commonwealth's theory was that Carnes, a man with no prior criminal record and no history of violence, experienced a spark of evil and executed four of his friends in order to steal their firearms. A spark of evil? Is this like, modern day witches? Like, what are you talking about? A spark of evil. What the hell kind of theory is that? Really? That was their theory? Robert Turner, who, according to the Commonwealth, was present during the murders and who later sold the stolen guns, was charged only as an accessory after the fact and received a 13-year sentence after a proffer session with prosecutors. Excuse me? The case against Carnes rested almost entirely on the testimony of two witnesses, Cynthia Small, Turner's girlfriend, and Maria Ortiz. Both women claimed Carnes confessed to them. What the jury never learned was that the Commonwealth paid Small $19,843 and Ortiz $26,100 for their cooperation, extraordinary sums that were deliberately concealed from the defense and affirmatively misrepresented in the Commonwealth Certificate of Discovery Compliance trial. No, sorry, that's a period. Commonwealth Certificate of Discovery Compliance. We saw that in Kelsey's case the other day or last week or something like that. That the Commonwealth had said they filed their certificate of compliance, discovery compliance, and Tim Bradle was like, not so fast because we don't have everything yet." So trial counsel has now provided an affidavit confirming she never received this evidence and would have changed her entire trial strategy had she known. On June 18th, 2008, after 9 days of deliberation, a jury convicted Carnes on all counts. He was sentenced to 4 consecutive terms of life without parole. Without parole. He has maintained his innocence from the moment of arrest. Now, the reason that I showed you guys Rosemary Scapiccio arguing first was, imagine these accusations coming out of her mouth when she argues this. She's like, this is the worst case. This gets her riled up. Wrongful convictions, you guys have to watch Trial 4 with her in it. It's on Netflix. She gets so riled up, and I would not want to be the prosecutor like in a case with her, because she means business and she comes correct. She's right, she does her research. She doesn't come like that with wrong information. Not that I've seen. Roman numeral 3. The real killer, Robert Turner's confessions and frame up. The evidence that Robert Turner, not Calvin Carnes, committed the Burnside Street murders is overwhelming and comes from multiple independent sources. The Commonwealth possessed much of this evidence before trial and withheld it. What's that called, babes? Brady violation? Brady violation. Additional evidence surfaced post-conviction, but was strategically delayed for up to 18 months. We've seen that in the Commonwealth, haven't we? 3 independent witnesses heard Turner confess. Craig Smith, Brian Cavett, and Felix Cruz, 3 incarcerated individuals who did not know each other and had no connection to Carnes, each heard Turner confess to the murders at different times and different facilities. Craig Smith, Turner approached Smith and told him he was the guy who murked the guys in the basement. I guess I've never heard that term. Have you guys? Turner said he lied to the police and the district attorney and blamed the murder on Cal. Turner provided Smith with a detailed account. Carnes had taken Turner to the basement to see if the men would sell their firearms. When they refused, Carnes stepped outside to smoke. While Carnes was outside, Turner asked to see a 9mm handgun, then turned it on the 4 men and shot them before stealing the remaining weapons. Smith wrote to the SCDAO, which is Suffolk County District Attorney's Office, on February 9th, the day before my birthday, 2009, to report Turner's confession. The Commonwealth sat upon this information for 18 months. Brian Cabot. Cabot, who was housed in the cell next to Turner, witnessed two separate incidents where inmates confronted Turner as a lying ass rat. It has a G on there, but I'm going to drop the G because that's how you guys do in Massachusetts. You add things, take things away. I love it. I'm here for it. So inmates confronted Turner as a lying ass rat. You lying ass rat. Turner responded by saying, "So what if I lied? I'm going home. You're not. What a ho ho ho." How'd he not get shanked in jail? I'm just wondering. And critically, how is Cal the gangster if I did all the shooting? The second incident occurred just one day before Turner's suicide. Oh, hmm. He said, "So what if I lied? I'm going home. You're not." And critically, how is Cal the gangster if I did all the shooting? The second incident occurred just one day before Turner's unaliving. This is interesting. This has all the things. And this is a cold read for me. I just saw what it was and, like, looked through it, and I was like, "This is something." Um, so Felix Cruz. Turner approached Cruz at the Nashua Street Jail before Carnes's trial and asked if Cruz could contact Cynthia and Maria, the two key prosecution witnesses, because they were from Roxbury. Turner also tried to sell Cruz an AK-47 and a Glock, the stolen murder weapons. After Cruz refused, Turner moved down the tier and told another inmate he had bodied, M word, all four of them. So now he's telling this guy Cruz, right? So Turner approached Cruz, right? Turner's the one who did it. Approached this guy Felix Cruz at the Nashua Street Jail before Carnes's trial. So before the guy that's wrongfully convicted, or wrongfully convicted, imprisoned, and asked if Cruz could contact Cynthia and Maria. Okay, the two key witnesses. So all three witnesses provided consistent accounts across their investigator interviews, police interviews, and testimony during the evidentiary hearing. None asked for compensation. None wavered under vigorous cross-examination by the Suffolk County District Attorney's Office. Smith had never even met Carnes. So one of these dudes had never even met the guy. Okay? This first guy, Craig Smith, never even met him. So all three witnesses provided consistent accounts across their investigation interviews, police interviews, and testimony during the evidentiary hearing. How often does that happen? I mean, you know, that's pretty convincing evidence to me. And none of them asked for compensation, which what could they get for compensation? Well, we see that their witnesses are getting paid already in this filing. And if, any one of them is doing time, they can maybe get a reduced sentence, right? So inducements, enticements, rewards. Um, okay, so by the Suffolk County District Attorney's Office. Do you know who used to work there? Tim Bradle used to work at the Suffolk County District Attorney's Office. He was a assistant district attorney there, I think. All right, so let's see. So pretrial confession evidence the Commonwealth concealed. Even more damning, the Commonwealth possessed evidence of Turner's confession before trial and never disclosed it. In October 2007 and November 14th, 2007, months before the May 2008 trial, two individuals identified as KW and KJ contacted the Suffolk County District Attorney's Office to report that Turner had confessed to them in detail, including information about where the firearms went after the M's. KW referenced an associate named Guapo as a possible participant, a name never associated with Carnes. KJ's attorney wrote the Commonwealth offering a proffer session. The evidence was not disclosed to Carnes until January 9th, 2013, over 4 years after conviction. It was not in the Commonwealth's paper file. It existed only in deleted computerized records. They like to get rid of shit. They like to delete shit. This is, you know, this reminds me of Kelsey Fitzsimmons' case. I hate to keep bringing it back there, but Tim Bradle asked for the police station camera from the day that Kelsey was in there doing her CPR training. Asked for it, and then after that, it got deleted. Come on now. Really? You think people aren't going to find out? Like, people are watching. People are watching. Thank you, cameras in the courtroom. Thank you, Melanie Little. Thank you, all you guys who are here and are equally as outraged with things like this happening, um, because it's it's a common theme. It's happening. The forged confession letter. Turner wrote a letter to his girlfriend Cynthia Small. Remember, she's one of the girls that got paid, right? Purporting to be from Carnes, in which Carnes confessed to the murders and expressed guilt and inability to sleep. Okay. So Turns wrote a letter to his girlfriend, Cynthia Smalls, purporting to be, oh, okay. So Turner wrote the letter acting like he was Carnes, and he confessed to the murders and expressed guilty and inability to sleep. The letter was returned to Carnes because the address was wrong. It was sent to 14 Ernest Street instead of Small's actual address at 16 Ernest Street. 14. Oh, 14 instead of 16. This simple error, 14 instead of 16, appears on envelopes from Turner's own letters to Small that the Commonwealth withheld until 2012. So they knew about this. They knew that he wrote a letter, Turner wrote a letter acting like he's Carnes and sent it to his girlfriend from jail, gets it returned to jail, like here he is on paper in writing. And they withheld it. A handwriting expert, Paul H. McDonald, examined the confession letter alongside known writing samples from both Carnes and Turner, excluding Carnes and concluding it was highly probable that Turner wrote the confession letter. Additionally, the usual contraction, you'll, meaning you all, appears identically in both the forged confession letter. I came to Yule because I trusted Yule. Okay. And Turner's suicide note, I never meant to hurt Yule. So he's meaning y'all. Y'all. How is he spelling it? Maybe it's like YAW, comma, or apostrophe rather, LL. I don't know. But they're thinking it's Yule, so whatever. The Commonwealth never hired a handwriting expert to dispute this finding. Can you imagine all this evidence that they have? Okay, so now Turner's unaliving of himself, self-deletion. On May 19th, and I know that I'm not monetized, so I don't know if it matters if I'd get stricken. I don't know. I'm learning the rules, but I'm trying to be in the habit of, you know, not saying words that will whatever. So Turner's unaliving. On May 19th, 2011, one day after inmates were confronting him as a lion ass rat, Turner was found hanging in his cell. His unaliving note, self-deletion note, which apologizes to his family. Sorry if you feel this was cowardice move. Sorry if you feel this was cowardice move. But as of late, things go out of order. I never meant to hurt you'll, but ends abruptly after the word but. Turner had previously contacted prisoners' legal services, reportedly feeling despondent. His death eliminated the possibility of ever calling him as a witness. Well, then, this is wild. I don't know. I'm going to take a look at your comments, Mary B. Oh, you guys are just chatting. Yeah, they do seem to just enjoy throwing people in jail and then keeping them there, and, it's so wild. It really is. So, the full scope of and this is gonna be great to watch her, I'm telling you. The full scope of concealed evidence. Massive undisclosed witness payments. The Commonwealth paid its two key witnesses, the only witnesses who claimed Carnes confessed, a combined $45,943. 26,100 to Maria Ortiz and 19,843 to Cynthia Small through memoranda of understanding executed before trial. This information was never disclosed. That's witnesses are asked, were you offered any enticements, inducements, rewards for your testimony? I've heard that. Have you guys heard that? Okay. Worse, the Commonwealth Certificate of Discovery Compliance, there we have that again, affirmatively misrepresented the payments, claiming that witness protection services were provided to a person who did not receive service at the time of her cooperation in this case. So it's saying that it was used to pay to protect one of the witnesses, which could be the case, but it also said that she did not receive services at the time of her cooperation in this case, and that the need arose from an unrelated case. This was false and is now entirely contradicted by the documents the Commonwealth finally produced years after conviction. Trial counsel has now submitted an affidavit averring she never received the evidence and that it would have been critical to her cross examination of these witnesses. I'd say. So it sounds like this trial counsel is in agreement. The concealed Turner proffer and cooperation. Emails discovered during post conviction discovery reveal that Detective Torres and a former ADA corresponded about a meeting with Turner and his attorney for a possible proffer session in May 2007. An unsigned proffer agreement dated June 12th, 2007, 11 months before trial, was located in the Suffolk County District Attorney's Office's files. Despite the Commonwealth's repeated denial that any proffer occurred, an email from Turner's attorney to ADA Wall on January 31st, 2008, discusses Turner's story in terms suggesting the Commonwealth was already familiar with it. None of this was disclosed to the defense. Lying ass bitches. Interception of privileged communication. Emails received that Detective Rock was listening to Carnes and Turner's jail phone calls, which happens, right? Including calls with attorneys. We know that's not supposed to happen, right? We know that's not supposed to happen without warrants or subpoenas. Rock wrote to the prosecutor that both of them have been told by their attorney not to discuss things over the phone. Hmm. Well, I wonder why. Rock also arranged for interception of Carnes and Turner's mail. So then he knew about the false confession being mailed out to the wrong address. This dude, Rock. He's still working for the Commonwealth? Little law girl, look that up for me, would you? Detective Rock. Hmm. None of these intercepted communications were ever disclosed. The intrusion into attorney client privilege communications is itself a constitutional violation warranting a new trial. I wonder if they were doing that in Kelsey's case. Just wondering. I don't know. I hope they like the coloring pages if they saw them. Well, no, because I'm not her attorney. Duh. They look at everything. Yeah. Duh. But they certainly shouldn't be looking at things, letters that she was writing or, with her attorney or, legal counsel. Uh, Coaching forensic analysts. A withheld email from the former ADA to a forensic analyst during grand jury proceedings asked for any suggestions on how to link Carnes to the crime through DNA evidence, noting that any corroboration of their alleged presence by way of it's objective forensic DNA evidence would be huge, 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 especially in front of a jury. Any corroboration of their alleged presence by way of objective forensic DNA evidence would be huge, 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 especially in front of the jury. Well, that's what the this communication, in which the prosecutor essentially asked a scientist to help build the case rather than objectively analyze evidence, was never disclosed. I don't I wonder why. Oh my goodness. Here's a question. So, if that did happen, tell me a scenario where they would tell the prosecutor or they would tell the defense attorney. They're not gonna tell you that shit in my uneducated opinion, or I'm not a lawyer yet, but I don't know what's out there. Maybe it does happen. Full cell phone tower testimony. Hmm. The Commonwealth used cell phone tower evidence at trial to place Carnes near the murder scene and to undercut his alibi that he was at 79 Florida Street. Detective Torres and Alex Eon from Verizon testified that Carnes' phone was connecting to a specific tower near the crime scene. An expert, Mark McFarland, has now provided an affidavit demonstrating this testimony was patently false. The Verizon records admitted at trial showed only which switch the calls connected to, not which cell tower. So I don't think it's going to say this, but if you guys don't know what a switch is, so just think of like the olden days phones, right? The switchboard. It still happens essentially the same way, um, but obviously many, many more steps now. But it's essentially the same, when you hear switch, that's what it is. Um, Okay, so each switch corresponds to between 3 and 10 cell towers spanning several miles. It was therefore impossible to determine which cell tower, let alone which location the calls connected to during the time of the murders. Neither Torres nor Eon had the qualifications to interpret cell site location data, and their testimony should have been excluded entirely. Torres was an impermissible substitute expert, testifying to opinions based on hearsay, conversations with a Verizon employee who Carnes never had the opportunity to confront or cross examine. Ain't that about a bitch? Like, they just let people testify like they're an authority, like they're an expert, a substitute expert. Yeah. I mean, they didn't Rosemary Scapicchio called him that, but that's exactly what it is, a substitute expert. Yeah. Unauthorized juror investigation. Here's some stuff. I'm looking forward to this. At the outset of jury empanelment, ADA Wall represented to the court that he had obtained criminal records for all potential jurors but had not looked at them, consistent with the procedure outlined by the SJC in Commonwealth v. Cousin. The SJC relied on this representation on direct appeal. You guys ready for this? This was the part where I was like, holy shit. Documents in the Commonwealth's file, however, tell a different story. The juror lists are color coded: green for minor infractions, blue for restraining orders, red for felony appearances or multiple defaults, and yellow for jurors plotted on a map. Okay. ADA Wall could not have created this color coding system without actually reviewing each potential juror's criminal record, right? I don't think they had ChatGPT back then to like sort things. Even if they did, it's not reliable like that. So, but anyway, I digress. Directly contradicting his representation to the court. So he got these juror files, background checks, and color coded them. This gave the Commonwealth an undisclosed tactical advantage in jury selection and raises serious questions about discriminatory use of juror information. Had trial counsel learned of this, she would have moved to strike the entire veneer. Can you imagine? Like, that is a huge advantage. Huge advantage. Number 7. The motion judges disqualifying conflict of interest. Oh my God. Judge Brady, that's a great name. Hmm. Oh my God, this has all the things. Judge Brady, who presided over both Carnes' trial and his first motion for a new trial, which we know because of Kelsey's case that they're not supposed to do that. It's not supposed to be the same judge. Wrote a letter of recommendation supporting ADA Wall's application for a judgeship, specifically citing that Carnes' case as evidence of Wall's exemplary prosecution. So, Judge Brady, the presiding judge, wrote a letter of recommendation for this ADA, his application for a judgeship, specifically citing the Carnes case as evidence of Wall's exemplary prosecution, which we know is not true from the first 6 Roman numerals. Let's see. So, in this letter, Judge Brady, I can't even make that up, praised Wall for instituting an open file philosophy on discovery and credited him with the high degree of professionalism, reducing the number of Brady violations within the SCDAO. These statements were made just 10 months after Judge Brady denied Carnes' motion for new trial, a motion centered on Wall's failure to disclose exculpatory evidence. The timeline is deeply troubling. Judge Brady denied Carnes' motion for new trial and discovery request in October 2013, before the evidentiary hearing was even complete, and then authored a recommendation letter for Wall in August 2014. He denied Carnes the opportunity to call Wall as a witness, denied further discovery, and denied a further evidentiary hearing while simultaneously vouching for Wall's integrity and the SCDAO's professionalism. As a federal magistrate judge observed in summarizing Carnes' habeas claims, any bias on the part of the trial judge in favor of the Commonwealth would be of critical importance. I'd say. Judge Brady's findings are internally inconsistent in ways. Yeah, that's right. Judge Brady's findings are internally inconsistent in ways that betray this bias. He found Craig Smith's testimony not credible because Smith had a criminal record, yet the Commonwealth relied favorably on testimony from Randy Furtado, a convicted armed robber and drug dealer in a separate case where Furtado was cooperating with the Commonwealth. Apparently, incarcerated witnesses are credible only when they assist the government. I love her snark. I really do. Number 8. The Carnes case within a systematic pattern. I think I need glasses. Like, I don't know. I can't get through. I don't know if it's the white background. I don't know. I don't know if any of the other creators have problems with. Like, I have a pair of glasses around here somewhere. The motion documents that the Carnes case is not an isolated incident, but part of a systematic pattern of Brady violations and prosecutorial misconduct within the Suffolk County District Attorney's Office. During ADA Wall's tenure as first assistant, when he supervised all superior court prosecutions, at least 13 men convicted of murder have since been exonerated. Want to take a look? Let's do it. Cases tried during oh my god. Cases tried during Walls' tenure where evidence was withheld. Keon Sprinkle, 18 years served. Undisclosed benefits to key witness. Coerced witness, coerced witnesses. Actual shooter confessed multiple times. Sounds like this case, right? Angel Toro, 21 years served. Alternative suspect report suppressed for 21 years. So, like, what is it with the Commonwealth? They better let this third party culprit stuff in for, yeah, truly. Sean Jenkins, 16 years served. $100 payment to grand jury witness never disclosed. 16 sets of cell phone records suppressed, showing victim called his drug supplier 5 times on the day of the murder. Dwayne Perry, 22 years served, died during proceedings. That's sad. After 22 years. Full scope of cooperating witness benefits not disclosed. Witness later recanted. Antoine Carter, 12 years served. DYS records proving key witness fabricated testimony were not disclosed. Witness coerced through perjury indictment. I've heard that before. I've heard of that before, where they'll get a witness to testify a certain way and they'll say that, oh, well, we'll hit you with perjury. I've heard of it in Massachusetts. Clarence Williams, 18 years served. Actual perpetrators made multiple confessions. Key witness recanted, saying police threatened to implicate him. See? Cases where the SCDAO opposed post-conviction discovery during Walls' tenure. Ricky McGee, 28 years served. $25,000 reward to key witness concealed for 27 years. Sean Drumgold, 14 years served. Prosecution hid witness deals. Commonwealth itself ultimately moved to vacate. Paul Robinson, 53 years served. Grand jury testimony showing co-defendant was the shooter suppressed for over 50 years. Did I miss that part? 53 years served. Holy shit. Anthony Mazza, 47 years served. Same suppressed grand jury testimony as Robinson. So as this guy. Damn. Sean Ellis. This is the guy from trial 4 that she represented. 22 years served. FBI informant reports showing victim detective was corrupt were suppressed. Lead detectives later convicted of federal crimes. Those guys, those police officers, were also charged with witness intimidation. I wrote a story about that on Substack, actually, on my Substack. Robert Foxworth, 29 years served. Informant report identifying actual killer suppressed for 25 years. Clarence Williams, 18 years, also listed above. Post-conviction process delayed 15 years while evidence of actual perpetrators existed. These cases collectively represent over 400 years of wrongful incarceration. The pattern directly contradicts every claim Judge Brady made in his letter of recommendation for Wall and underscores the institutional failure that allowed Carnes' conviction to stand. Almost done, guys. Additional constitutional violations. Exclusion from sidebar discussions. Carnes was excluded from all sidebar discussions throughout his trial without ever being informed of his right to be present and without any waiver colloquy. He did not learn he had this right until, during deliberations, a substitute judge invited him to sidebar. He's like, oh shit, I can come up there? The failure to secure a knowing intelligent waiver of this fundamental right violated his 5th, 6th, and 14th Amendment protections. I don't was Karen offered that? Because she went up during the second trial. That's interesting. Missing trial records. An entire day of jury impanelment and the official recording of Judge Brady's jury instructions are missing from the record. Carnes cannot adequately address claims relating to the impanelment process, including the Commonwealth's unauthorized juror investigation or the jury instructions without these records, forcing Carnes to reconstruct the record using notes from the prosecutor who engaged in misconduct and counsel who was ineffective violates his rights to meaningful appellate review. Yeah. Ineffective assistance of counsel. Trial counsel failed to investigate the forged confessions letter, failed to hire a handwriting expert, failed to present a third party culprit defense, failed to consult a cell phone tower expert, and failed to object to the false cell site location testimony. Trial counsel's own affidavit confirms these were not strategic decisions. She did not appreciate the need to investigate because the Commonwealth had withheld the very evidence that would have revealed these avenues of defense. Piecemeal disclosure denying full appellate review. The Commonwealth's strategy of disclosing exculpatory evidence in fragments, withholding Turner's confession for 18 months until after appellate briefing and argument, producing witness payment evidence 4 years post conviction, revealing the small letters 6 years after trial, denied Carnes the ability to present a complete picture to any single court. He was forced to raise claims piecemeal, foreclosing the comprehensive review that the cumulative weight of this evidence demands. Part 10. The relief requested and the path forward. So, what do we want and how are we going to fix this shit? Carnes' second motion for new trial asked the court to grant a new trial or, in the alternative, to hold a new evidentiary hearing where all claims can be evaluated together by an unbiased judge. Carnes asked this court to reassess his first motion for a new trial in light of Judge Brady's documented conflicts of interest and to consider the newly discovered evidence, including the defense's expert affidavit debunking the cell tower testimony, the color coded jury list demonstrating the Commonwealth's unauthorized pre impaneled investigation, and trial counsel's affidavit confirming that the withheld evidence would have fundamentally changed the defense strategy. The cumulative weight of the evidence is staggering. Yeah. Multiple independent witnesses heard the actual killer confess. A handwriting expert confirmed the actual killer forged a confession letter to frame Carnes. The Commonwealth paid and that other dude knew about it. That detective knew about it because he saw the mail coming in and out. The Commonwealth paid its two key witnesses nearly $46,000 and lied about it. The forensic evidence the prosecution used to undermine Carnes' alibi was demonstrably false. The Commonwealth intercepted privileged attorney client communications. The juror investigation violated the procedures the SJC relied upon in affirming the conviction. And the judge who denied relief was actively championing the career of the very prosecutor whose misconduct was at the heart of the case. Calvin Carnes has now spent nearly 18 years in prison for a crime he did not commit. The real killer is dead. The evidence that could have saved Carnes was in the Commonwealth's possession all along. Justice demands that this conviction be vacated. For further information about the Carnes case or to discuss how your organization might assist, please contact Rosemary Curran Scapiccio, Esquire, and Jillian McDonough, Esquire. They're down at the wharf, Union Wharf. Nice area down there. Do we see her office? I don't remember if we saw her office when we were down there. So what do you guys think about that? That's some stuff, huh? Pretty wild. Pretty wild.